All right, court is calling 2024 CR 2928B, State versus Curtis Ray Wilson. Can I have parties announced for the record for the state?
Andrew Harris, Salem.
Defense?
Bud Rittenhour for the defense.
And are you Curtis Wilson?
Yes, ma'am.
All right, you entered a plea on November 7th to aggravated assault with a deadly weapon. According to the plea bargaining agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon. State opposes your application for deferred adjudication. This will run concurrent with 2024 CR 2927B. And the state is taking into consideration some cases. When it says that it's running concurrent,
There are two pleas, Judge.
all right, I don't have the other plea paperwork.
No, they're not into yours.
No problem. All right, and also 2024 CR 2927B. And that cause number, you entered pleas to count 1 and count 2. The state waived count 3. And that's a deadly conduct discharge of firearm. And according to that plea bargain agreement, punishment is to be assessed at a cap of 10 years. And it's to run concurrent with 2024 CR 2928B. And there are 2 other cases that are being taken in consideration. Have both parties had a chance to review the PSI report and the TAP evaluation?
Defense has, Your Honor.
Any objections to the PSI report or TAP evaluation? State?
No, Your
Defense?
No, Your Honor.
Any witnesses? State?
Honor. No, Your Honor.
Defense? Any witnesses?
Judge, we have none to testify. I provided the court a motion I filed this morning with statements from members of the family. We do have 3 members of the mother, father, and stepfather are present in court in support. They're not asking to testify.
All right, any objection to the court reviewing the letters of support?
No, Your Honor.
All right, just give me a moment. Let me review that. And the letters of support are from the defendant's father, former teacher, cousin, stepfather, and mother.
That's correct.
All right, the court has reviewed the letters. All right, state your post.
Yes, sir.
All right, why are you opposed?
Nature of the offense, Your Honor.
All right, defense.
Obviously, we're asking for the deferred adjudication, Judge. We'll get here in both cases by law of parties and not by direct action by him. Mr. Wilson was 19 years old. In fact, it turned 22 months ago at the time of this offense. He has graduated from high school actually withdrew from Sam Houston, finished it online, home tutored by his mother. He had just gotten with the wrong people, going places, not questioning where he was going. He and I have talked a great deal since he's been incarcerated. He understands that you can't just pick up with people and go and not ask what's going on. He has some positive plans as indicated by the letters for his future. The young man has a good head on his shoulders and a good positive attitude and definite plans for the future. Sending him to prison at this point in his life is certainly not going to do anything for him or society. Giving him a chance on deferred, understanding the full weight of the punishment is pending over his head should he not make it. He's motivated to finish that, get out there, get training, and just become a productive member of society. He intends eventually to own his own business, looking at truck driving and some other things. So he's looking at the future. He's had a lot of contemplation since he's been in custody. He certainly does not apologize, is not the right word. He's almost ashamed that he was involved in this thing. At the scene, he was a passenger in a vehicle. He knows he shouldn't have been there. We're asking for the court to give him a chance.
All right, just one moment. Okay, the defense is saying that he did not know what was going on or what was going to happen. Do you have any response for that?
I've been focused on a bit more in his pre-sentence investigation report. With this, everybody makes mistakes. You make a mistake, don't do it again. I got caught up with something because I was with other people. Well, Mr. Wilson doesn't actually acknowledge what mistake it is that he has made. And as far as I can tell, abdicates responsibility for the choices that he made. He got caught up with something because he was with other people. Not, he chose to be with those people. He chose to do what they did. He got caught up. As far as I can tell, Mr. Wilson still refuses to take responsibility for his choices. And as long as he's going to refuse to take responsibility, he belongs in prison.
All right, so I'm reviewing the facts of the case, and in the facts of the case, it says that they were, the person identified him because they knew him from school. He identified which position he was in, and that a person went in with a mask on. So all right. So what has, let's see, just a second. We're back on the record in 2024 CR 2927B and 2024 CR 2928B. Defense, did you have a chance to confer with your client?
I have, Your Honor,
Yes.
and given the choices we have, we'd ask that we'd like to withdraw the plea and get trial setting.
All right, Ms. Ferguson, can I have a jury trial setting on Wilson? State, how long do you expect this trial to last?
4 days.
All right.
You can do March 4th.
All right, your jury trial date will be March 4th.
Understand?
Thank you.
Thank you, Judge.
Wilson, Ferguson.